Hearing in the appeals, Suffolk Coastal District Council and Hopkins Homes and Richborough Estates Partnership and Cheshire East Borough Council.
Mr. Kingston. Mr. Kingston.
My Lords, your Lordships have what I might describe as a cast list.
Yes.
For those who are here. Perhaps it would be helpful if I indicated that I appear with my learned friend Mr. Hugh Richards, Mr. Jonathan Clay and Dr. Bowes on behalf of the appellants. And they are arrayed each side of me. The other three, Mr. Lockhart Mummery and Mr. Simons on behalf of Hopkins. Mr. Lockhart Mummery here, Mr. Simons behind, Mr. Christopher Young and Mr. Corbett Bircher on behalf of Richborough, Mr. Young in the middle here, and finally, and by no means least, Mr. Herbert Philpott at the end on behalf of the Secretary of State with Mr. Honey behind.
Thank you.
My Lords, there are some additional documents.
Yes.
They are of a variety, if I may. First of all, there is an authority, Matthews, which is at the back of the additional bundle that you've got.
Thank you.
On the desk, I hope, in front. It needs to go into volume 2B, at tab 29. The wrong Matthews got into the bundle.
Don't think what do they look like? Is that a bundle? What does it look like?
It looks like this. It's just, it's in there.
Behind the plans, my Lord, in the additional papers that are handed in.
Thank you very much. Yep, thank you. Yep.
Then there are three plans and 2 Google Earth images.
Yes.
Taking the plans in order, the first should look like that and is an A3 and colour version of the plan in volume 4B at tab 53. Then there is a plan that should look like that, which is an A3 version, again in colour, at tab 54 of volume 4B. There is then a plan which should look like that, which is from tab 55 and relates to the Suffolk coastal appeal. The only difference is that this time it's helpfully in colour, which allows one to understand what it's showing rather than being something of a mystery. And then there are 2 Google Earth images, which are simply intended to highlight some of the features in the areas of each site and to add some flesh to the plans. They may help in considering what features the inspectors referred to in the 2 decision letters. My Lords, I'll come to the plans, if I may, in just a moment. There is one additional authority sent to the court last week, Adedoyin, and the Secretary of State for the Home Department, which I hope the Lordships have a copy of.
Possibly. It's like this.
At least some of my Lords have a copy of it. I hope
Yes, very well.
it's reached
yes.
everyone.
Yes.
Thank you. My Lords, in these conjoined appeals, there are 4 issues. Issues 1 and 2 relating to the interpretation of paragraph 49 of the National Planning Policy Framework are common to both appeals. Issues 3 and 4 relate only to the Suffolk appeals.
Yep.
I shall make submissions with regard to the issues common to both cases, that is issues 1 and 2. Mr. Clay and Dr. Bowes will deal with issues 3 and 4. My Lords, I make these submissions against the background of the written cases, the statement of facts and issues. I don't seek to repeat it or go through it. May I then deal with a little orientation by reference to the plans which your Lordships have just received. And first of all, the additional plan at tab 53, this is the proposals map from the Crewe and Nantwich replacement local plan. The purpose of it is simply to indicate, by way of the green hatching, which is on the proposals map, where the green gap policy NE4 relates to. And if your lordships would at the same time have to hand the plan which is the replacement plan for tab 54, you should now be able to see, because it's been marked in colour, more or less in the centre of the plan, where the numbers 1 and 2 appear for the photographic viewpoints, the location of the appeal site in the Cheshire East Appeal. You'll see, by reference to the earlier plan, that it lies in the green gap between Williston and Rope, and that's the NE4 area. To the left on the plan, the large urban area is Nantwich. To the right, the large urban area is Crewe. My lords, then moving to the Suffolk site and the plan which your lordships have at tab 55. The appeal site should be hatched in blue on it, more or less in the centre. The green coloured
Just
areas,
under Yaxford.
yes,
Yoxford, sorry, yeah.
Yes, that's it, my lord, yes, just beneath that.
Yeah.
The green coloured areas are the non-designated heritage assets identified in AP4 of the saved policies related to the Suffolk Coastal Appeal. There are 3 of them. You can see that they are around Yoxford. And in addition, on the same plan, you'll see that the settlement area is marked with a physical limits of the village red line. And outside of that, the local plan special landscape area edged with the blue-green line. That's an area which is subject to policy AP13 in the saved local plan.
That's a historic parkland, is it?
No, the AP13 yellow-green line is the special landscape area. The historic parkland, the AP4 areas, are the green shaded areas.
Well, I was just looking at where it says SPG 6 historic parkland.
Yes, SPG 6 historic parkland, that is unfortunate. It should be coloured, really, although the green edging is intended to delineate it. Round the green shaded areas, there's a darker green edging. It's all that is AP4. And if your lordships wanted to line that up with the policies which relate to
SPG 6 is the same as AP4, is it?
Yes, in substance, SPG 6 was giving guidance, supplementary planning guidance, hence SPG, supplementary planning guidance with regard to...
And what is historic about it?
Could I, in answer to that question, invite your lordships to take up bundle 4B? And within that, go to tab 52. Which should be the Suffolk Coastal Local Plan remaining saved policies. In this list of saved policies, page 2563, you should find on 2563 AP4 in the left-hand column, Parks and Gardens of Historic or Landscape Interests. I won't read it, but my lords should note what's said at 131 and 132. In essence, the district has 3 rural parks included in the national register, but at 133 you'll see the other parks and gardens, although not recognised by such designation, nonetheless important. Their character and appearance should be safeguarded. The list of such sites includes, and in that list, in the left-hand column, just over halfway down, you should find Cockfield Hall Park, Yoxford. That's the one on the plan, as it were, at the top right. So, if I may, in that position, Cockfield Hall. Then below it, and still on the right, Rookery Park. And the one particularly referred to by the inspector in his decision letter, Grove Park, the one on the left-hand side of the plan.
Sorry, which bit on the left-hand side of the plan? The green bit?
Grove Park is that one, my lord, and that Grove Park and Rookery Park you can see in the list in the right-hand column under paragraph 133.
So Grove Park is the one with the development site.
Yes, that's correct, and referred to by the inspector and the subject in due course of submission from my learned friend Mr. Clay.
Yes, indeed.
And as to historic interest, the explanation of that, so far as it's within the plan as opposed to the SPG, is in what follows on page 2564.
So we don't know what's this. I mean, I was just purely out of interest. I was wondering what was the history.
Oh, yes, there is an explanation of Grove Park. If you go to the appendix part 2, page, well, last page, the very last page.
All right, well, I can read that for myself.
Well, and this is from SPG 6, and there is an interesting paragraph or two
Yes.
about it,
Thank you.
together with a picture to enliven it somewhat. The Google images were simply intended to add some life and literally colour to what your lordships have. There's nothing further I think I need to draw attention to. They're produced in part because some of the features shown on them, for example, Rope Lane on the Cheshire East Appeal, are features which the inspector referred to in his decision letter, and it seemed helpful at least to provide something which would allow your lordships to orientate yourselves. Unless there's anything further with regard to orientation, the sites and their locations, I leave those matters. Turn, if I may, to a brief overview of the appellant's case on issues 1 and 2, in respect of which I make 3 points. Firstly, properly interpreted, the framework is not intended to and does not override up-to-date policies in the development plan, put in place to identify areas which the development plan itself has identified are inappropriate for development because, for instance, of their environmental, social or historic significance. Secondly, important as housing is as an element in the framework's policies, it's not a form of development which the framework identifies is to be pursued at all costs. It does not in any sense trump other aspects of the framework's policies on, for example, environmental protection. And third and finally, the framework was drafted so as to be accessible to non-specialists. It's to be read as a whole, and so to be internally consistent as between the different policies it advances. It should not be interpreted so as to put it at war with itself. My Lords, before turning to deal with more detailed issues with regard to issue 1, I'd like to set out some overarching principles which we say should inform any consideration of the issues in relation to 1 and 2. I shall refer to some authorities, but they're authorities which are well known, recited in the written cases, and unless your lordships wish it, I didn't intend to turn to them in detail. Firstly, planning control is a creature of statute and is operated in accordance with the Comprehensive Statutory Code. The authority for that, the Pioneer Aggregates case. Secondly, that comprehensive statutory code is a very elaborate and carefully drafted code, the operation of which requires a significant involvement and investment from local planning authorities, local people and others in its operation. It is no small matter to reduce the weight which might be accorded to its policies, and it should only be done when it's clearly signalled in either the statute or any policy. And if I may interpolate there, just as an indication of what sort of lengthy processes are involved, if your lordships could take up bundle of authorities 4B again, and go to tab 51, which is the Suffolk Coastal District Local Plan, and page 2401. In the left-hand column, with the subheading, the preparation process, including public consultation, starting at paragraph 110, your lordships will see the process that was gone through. I won't read it, your lordships are able to read it, but I draw attention to 110, the start of the process, the statement of community involvement, 111, the number of processes involved, who was involved in them, and at 112, at each stage, the strategy has evolved as options and choices have been debated. And that is an example.
I mean, this is a pretty up-to-date plan by most people's reference.
Yes, it is.
I mean, it's gone through the process.
Yes.
By contrast with the crew one, which is pretty out of date.
Rather over.
Yes, I mean, it's quite interesting. We've got the two different types of position.
Yes, we have.
This one, I think, and I picked it up somewhere, the inspector, when this was approved, did reserve the position in relation to housing, didn't he?
Well, he reserved it in the sense...
I was hoping you'll show us that at some point.
Yes, I could do that, certainly. And
No, I mean, it seems to be fairly relevant when one's considering how up-to-date a plan is, what the inspector who examined it on behalf of the Secretary of State said about it.
Yes, whether or not we're allowed to do so, we'll come to in just a moment. But taking my Lord's point, if I could just add briefly an explanation. For the reason which my Lord has just identified, that lots of plans are old, the Secretary of State is anxious to get the process moving and has therefore invited inspectors to look for ways to do that. One way is to get the authority, if the inspector doesn't think they've quite got it right in terms of the amount of housing land provided, is to get the authorities to commit to an early review. So the authority adopts the plan, sound at the date of adoption, with the inclusion of a commitment to an early review. And that's in essence what was happening here in order to try and ensure that there was...
You're not saying we can't take that into account, are you?
Well, I'm not alone in that, and if your Lordship will let me progress through these overarching principles, I'll come to the point, because to be frank, some of the submissions are a little schizophrenic in that regard.
Little what?
Schizophrenic. They look in both directions, both yes and no.
Yes, all right. Well, we'll come.
Not at all. Let me come to it. I've no problem with it myself from a practical point of view, but there is some fairly robust Court of Appeal authority which says...
Why is it a point of law? It's very obvious that if you've got a plan which is approved on the basis it's going to be reviewed, that you look at it in that light. I mean, I can't say... Anyway, come to it in due course.
I will. But if my Lord would simply...
One of the joys of being here is we're not bound by things said in the Court of Appeal.
And if I may say so, I'm fully cognizant and have cause to be very grateful for that on more than one occasion.
No, I may not. I see you.
But
this morning was such a case.
No, my Lord, if your Lordship would simply write a post-it note and write on it TW Logistics, tab 33 in volume 2B, then we'll come to it in due course and examine whether or not your Lordships want to say the Court of Appeal was right or wrong. But there we are. Let me get, if I may, making some progress, my third overarching principle. In the statutory code, there is a presumption in favour of the development plan, the effect of which is to give a priority to the development plan in the determination of planning matters. That's Lord Clyde and the City of Edinburgh Council case. The presumption is rebuttable, but it serves as a reminder of the importance of the development plan in the statutory scheme as a starting point in the determination of planning applications. Against the background of the elaborate statutory code and involvement of many agencies, the Act's presumption in favour of the development plan is not whimsical. It's founded on the effort and investment that is put into the production of such plans. Fourthly, the Secretary of State's power to formulate policy is not an unconstrained power when dealing with planning matters. The policy must relate to land use planning and be consistent with whatever Parliament has put in place by way of the statutory framework for planning, which is here intended as a complete statutory code. The Secretary of State cannot...
Do you have these propositions on a piece of paper?
I could reduce them to a piece of paper, my Lord.
For my part, I'd be grateful for that.
Well, I could...
Otherwise, I shall never keep up with it.
No. Well, in that
We
case,
won't anyway.
but by tomorrow morning, if I may,
Thank you very much.
I or Mr. Richards will have reduced them to a piece of paper.
Thank you very much.
So the Secretary of State's power to form policy, the Secretary of State cannot, by policy, we submit, seek to countermand or frustrate the effective operation of Section 38(6), that is, the development plan comes first. That's a proposition which is founded on a paragraph which has caused a little disquiet, paragraph 22 from the judgment of Lord Justice Laws in the West Berkshire case. The other part, which was the subject of the court's direction in the letter earlier this month, I'll deal with separately. But the last sentence of the paragraph I rely on.
You coming to that?
I will come to it. Fifthly, in the context of the Comprehensive Statutory Code and outside of the Statutory Development Plan, all else is other material considerations. National planning policy, in the framework or indeed elsewhere, is one such other material consideration. Sixth, in the interpretation of policy, whether contained in the development plan or any other policy document, the policy statement should be interpreted objectively in accordance with the language used, read, as always, in its proper context. That will be familiar from Tesco and Dundee and from Lord Reid at paragraph 18. And finally, the proper context is not as a matter of law restricted to the policy document in which the policy statement appears. A wider context may need to be considered. In this instance, the framework itself clearly provides ample evidence that the context for its interpretation includes the statutory framework. And for those purposes, my lords, one might just take up the appendix, and the framework is in Appendix Part 2. It starts at page 206, that to make good the point I've just referred to, if your lordships would go to page 212, paragraph 2,
yeah,
with its reference, my lords will see, to planning law requires and so on, clearly setting the framework and what follows in the context of the development plan.
yep,
There are many other examples. I take one more for present purposes at page 214,
yep,
paragraph 12.
thank you.
This framework does not change the statutory status and so on. In addition, and still with this point of what is the proper context, the courts have quite clearly indicated that in some circumstances it's appropriate to look outside of the policy document, and have done so with regard to the framework. And so, if your lordships would take up the Authorities, Volume 2B, the authorities' volumes are all green covered and the
Yes.
appendices are blue.
Yes, that's not unusual.
Red Hill is at tab 33.
Yep.
Red Hill Aerodrome
Yep.
against the Secretary of State. And my Lord should note that the Secretary of State was a party to this case. This case was all about the proper interpretation of Greenbelt policy in the framework. The head note on the first page sufficiently explains the background. That there was a debate, in essence, as to what the phrase "any other harm" meant. At first instance, the judge had reached a particular view with which the Secretary of State robustly disagreed. And the issue then in the Court of Appeal, you can see explained at paragraph 3 of Lord Justice Sullivan's judgment, page 1569. There then follows, as one might expect, with Lord Justice Sullivan, if I may say so, more or less elegant explanation of the position. But if you go
More or less elegant.
Elegant, more or less, depending on your view. I dare say Red Hill
There were
Aerodrome.
some less elegant bits.
Well, I dare say Red Hill Aerodrome were less than impressive.
Well, anyway, this is what he said.
At
Yep.
paragraph 16,
Yep.
Lord Justice Sullivan said, if it had been the government's intention to make such a significant change to Greenbelt policy in the framework, one would have expected that there would have been a clear statement to that effect. Mr. Sosowski accepts there is no such statement. In my judgment, all of the indications are to the contrary. And the judge then identified 3 indications which he clearly took into account in the construction of the framework. The first, at subparagraph 1, is the earlier policy in PPG 2, Planning Policy Guidance 2. The second is the impact assessment in respect to the framework published by the Department of Communities and Local Government in July 2012. The judge took into account what was said in that impact assessment. The third is the Secretary of State decisions in other cases which were giving no indication of any change. So, my Lords, it is, we submit, quite clear in that case that in construing the framework, the Court took into account considerations outside the framework, those in particular identified at paragraph 16. More broadly, as to the approach the Court will take in relation to policies of this kind, if my Lords could take up the additional authority, and I hope I pronounce it correctly, Adedoyin, which came separately last week. This is an immigration rules case. In essence, the question was, what was meant by the expression false representations? You'll see that in the middle of the first paragraph of the head note. What was meant by false representations in the rules? Did it mean simply as a matter of fact false, or did it mean dishonest? And the Court then had to consider that matter. Clearly, the subject matter is rather different, but I submit of interest from our point of view here is what Lord Justice Ricks said in the submissions, dealing with the submissions part of the case, in particular paragraph 61. He refers to MO and then quotes extensively from Lord Brown in that case. My Lords, I won't read it out because your Lordships can read it, but in essence, at the bottom of that page, you'll see the submission made that the rules are essentially executive, not legislative, going over the page, quoting paragraph 38, we see Lord Brown has said, in my opinion, the true analogy is with planning law and practice, which requires that all applications are determined in accordance with whatever policies are in force at the time the decision is taken. And so there was the analogy. And at paragraph 63, having referred to Mahad, Lord Brown is quoted again, and it's simply the first 5 lines of paragraph 10 that I refer to. They are statements of the Secretary of State's administrative policy. Over, if you would, to the discussion at paragraph 65, which tells one in the opening part what the question was. I won't repeat what I've said already about it, but in essence what I've said about the issue was taken from that paragraph. And then on to paragraph 70. Lord Justice Rick said, fourthly, it seems to me in a situation where a word such as here false has 2 distinct and distinctively important meanings, there's a genuine ambiguity which makes it legitimate in construing rules which are expressions of the executive policy to consider what the executive has said publicly about its rules. Clearly, what a minister says in Parliament, expressed as an assurance, and especially on the occasion of a debate arising out of the tabling of amended rules, is of particular and maybe decisive importance. He continued in paragraph 71, fifthly, therefore, I consider it necessary in the present case to consider what assurances were given and arising out of the Lord's debate when the rule in question was before Parliament. And he refers to Lord Bassam making a clear statement. And then, if you would, to paragraph 86, which is a part of the judgment of Lord Justice Longmore. It starts by referring to what has unfortunately occurred in terms of the construction of Rule 322(1)A, and then continues over the page, having referred to the immigration rules are statements of policy, not the law of the land. In these circumstances, formal statements in Parliament or in correspondence with interested parties cannot be gainsaid by the Secretary of State when it comes to interpreting the rules. My Lords, I respectfully submit that applies here, and I shall in due course invite your Lordships to look at the material which is in Authorities Bundle 4A as a part of what we respectfully submit as a legitimate exercise in interpreting what the Secretary of State's policy means in the framework. My Lords, the question raised by these appeals is a short but important one relating to paragraph 49 of the framework. It's important because of the significance of the provision of housing as one, but only one, it has to be said, of the government's policy objectives. And it's important in practical terms because of the number of planning applications which arise throughout the country, week by week, engaging with the issue of housing land supply. So, my Lord, I deal first of all with our approach to interpretation dealing with the statutory context. I've made some submissions as to the overarching position with regard to the statute. Our consideration of the context for the interpretation of the framework starts with the Comprehensive Statutory Code. That's where the framework starts, and I've drawn your Lordship's attention already to paragraphs paragraphs 2 and 12. We might, for good measure, and by way of variety, but definite addition, look at the framework at paragraph 17 on page 216 of part 2 of the appendix. Page 216. And I'm sorry if the if the printing has not been very kind to the coloured parts of the document. But the heading above paragraph 17 should be core planning principles. And I draw attention firstly to paragraph 17 and the first one, the introduction in the first part, and then these 12 principles are that planning should be genuinely plan-led, empowering local people to shape their surroundings, succinct local and neighbourhood plans, setting out a positive vision for the future of the area. Plans should be kept up to date, based on joint working, provide a practical framework within which decisions on applications can be made with a high degree of predictability and efficiency. And one other paragraph a little later on, paragraph 150, which is at the beginning of the part of the framework which deals with plan making, and under a subheading local plans, and repeating language which is used elsewhere, local plans are the key to delivering sustainable development that reflects the visions and aspirations of local communities. Planning decisions must be taken in accordance with the development plan unless material considerations indicate otherwise. All of that giving us a flavour of what this is about. The key role of local plans is, we submit, clear. Lord Reid remarked in Tesco and Dundee that the development plan is a carefully drafted and considered statement of policy, published in order to inform the public of the approach that will be followed by planning authorities in decision-making unless there is good reason to depart from it. And that's from paragraph 18, again, a paragraph which is repeatedly referenced in the written cases. Lord Reid's statement is, I submit, fully supported by the detailed and elaborate statutory code which supports the development plan-making process. The Lordships have seen an example of it in the Suffolk case that we've referred to already. But in connection with Lord Reid's statement, and by way of summary only, we draw attention to the following matters. First of all, the statutory code itself, that is the Planning and Compulsory Purchase Act 2004, part of it. And for this, my lords, you will need the authorities, volume 1. And tab 1. This is the Planning and Compulsory Purchase Act 2004. I'm not proposing to, for very obvious reasons, read through sections of the Act. I simply wish to draw attention to a number of sections which support Lord Reid's proposition and our submission. And I start with section 15 on page 880, which is the local development scheme. And I draw attention to what it is that the local authorities must do, what the scheme must specify. At 2F, there must be a timetable and such other matters as are prescribed at the bottom of page 880, flagging up the existence of regulations. Note on page 881, the Secretary of State's power of direction to amend the scheme, signalling, among, in other ways, the importance of it. If your Lordships would then go on to page 887, section 17, development plan documents. What is a development plan document is defined in the regulations we'll come to in a moment. Regulations at tab 3, regulation 5, but for the moment, section 17, the local planning authority's local development documents must, taken as a whole, set out the authority's policies relating to the development and use of land in their area. So, an injunction there in clear terms. 5, subsection 5, if to any extent a policy conflicts with any other statement, the policy prevails. The scheme flagging up the importance of the policy as opposed to anything else which might be in the document. Page 890 and section 18, something which your Lordships will have seen in the list of matters that was gone through in the Suffolk plan, the statement of community involvement, a very important matter, engaging with the public, an express matter in the framework, must prepare a statement of community involvement. It's a statement of, your Lordships can see, subsection 3, describing its status, 3A, not specified in the local development scheme, but an important element. Over the page, excuse me, page 892, preparation of local development documents, section 19, prepared in accordance with the local development scheme. 1A, a specific matter introduced with regard to climate change. 19.2, in preparing them, local planning authority must have regard to A, national policies and advice contained in guidance issued by the Secretary of State, and other matters which have been the subject of modification because regional strategies have, of course, been abolished. On the next page, 8.9.
I mean, that's quite important, isn't it, 19.2a, because there you do see the scheme providing for national policies to come into the picture,
yes,
but at the plan stage, preparation of the plan stage.
Precisely so.
And as we see, the Secretary of State has power to sort of require the plan to be amended if it doesn't.
We shall see precisely that in a moment, and it is important.
But we get nothing equivalent to that when we come to the determination of individual planning applications.
No. What the statutory scheme does is to say you must have regard to the Secretary of State's policies when you formulate your plan, but when you make your decisions on planning applications, you must determine the applications in accordance with the plan, unless other material considerations indicate otherwise. And that's an important part, as my Lord says, of the scheme. 893, subsection 3, must comply with the statement of community involvement. Subsection 5, there must be a sustainability proposal, and as you can see, a report prepared, so it's got to be a document which has been considered as to whether or not it's adopting a sustainable approach. Page 895, a very important consideration, independent examination.
Yep.
What does independent examination involve? As my Lords will see, looking at section 20, by a person appointed by the Secretary of State, subsection 4, his duties at subsection 5 to determine whether, in effect, the regulatory requirements have been met, and then at 5B, whether it is sound. And my Lords, that as a piece of draftsmanship might leave one wondering what the draftsman had in mind. But so that we should not wonder too long, the Secretary of State produced the framework, and in the framework explains to us what sound means. And I interpolate here in the statutory scheme because it becomes important when considering overall what view we're to take of the development plan.
Now, wait a minute. The statute says sound.
Yes.
Is there any specific power giving the Secretary of State power to say what this means?
No. The Secretary of State's power, in essence, with regard to the formulation of policy, relies here, depending on one's view, on either the existence of, as it were, a subsidiary power related to the operation of the town and country planning system and the requirements of it. So, for example, we've seen that the planning system provides, by way of the development plan, for national policy to be taken into account. Someone might take the view that if national policy is to be taken into account, that there would be, at least by implication, a power in the government to formulate it. Some have taken the view that there is a residual or third power available, which extends to providing for the government the ability to formulate policy.
I mean, that's a slightly different point, I think. The question here is whether the Secretary of State can do more than tell us what he thinks sound means.
No.
What it does mean is a question of law, is it?
Yes. He can tell us what he thinks, and he's told us what he thinks, which is where I was on my way to.
That's exactly the point I was...
Yes, well, precisely so. But that's, as you'll see in a moment, rather my point, that the Secretary of State can tell us what he thinks.
I mean, no one in this court is saying that his interpretation of the word sound is the problem.
No, no, not yet.
Not yet.
So if you take up the appendix part 2 and go to page 254.
Thank you.
This is in the framework.
Yep.
Paragraph 182.
Thank you, yes.
Examining local plans, examined by an inspector whose role is to assess various requirements and whether it is sound. A local planning authority should submit a plan for examination which it considers is sound, namely that it is. And then there are the 4 elements. Positively prepared. Plan should be prepared based on a strategy which seeks to meet objectively assessed development and infrastructure requirements, including unmet requirements from neighbouring authorities. So quite clear, prepared on that basis. But the following phrase is important in the light of our discussion a little later, where it is reasonable to do so and consistent with achieving sustainable development. So this is not development at all costs to be sound, it's where it's reasonable to do so and consistent with achieving sustainable development, justified, most appropriate strategy based on a proportionate evidence base. So you don't promote policies which haven't got a supporting evidence base. Effective, should be deliverable over its period based on joint working cross-boundary strategic priorities. Consistent with national policy, the plan should enable the delivery of sustainable development in accordance with the policies of the framework. So that's where the Secretary of State tells us what his view of soundness is, and what it is that an inspector will be considering when undertaking the examination pursuant to Section 20. Also important in Section 20, back to the section at the bottom of page 895, any person who makes representation seeking to change a development plan must be given the opportunity to be heard before and be heard by. So here is an important opportunity for participation in the process, which is something, as your Lordship will have seen from the framework, the government is keen to encourage. Over the page, the various duties of the person appointed to carry out the examination, in essence, provided the person carrying out the examination is satisfied that the legal requirements, including a requirement introduced into the Act related to the duty to cooperate, have been met, then the person undertaking the examination can, if invited by the authority, make recommendations to make the plan sound. The authority must then, in essence, adopt it in accordance with those recommendations. My Lord, still in the statutory scheme, Section 21, page 898. Intervention by the Secretary of State. This is signalling the importance of the process. Elaborate provisions here, I won't go through them, my Lords, I invite noting of them. Elaborate provisions to allow the Secretary of State to intervene and, in effect, if he thinks it appropriate, to take over in the production of the plan. Page 903, the process of adoption, which engages, as you can see, with the inspector's recommendation process. The whole of that taken together, I respectfully submit, fully supporting what Lord Reid said about development plans and the way they are produced.
Is there a provision, the normal provision, for challenging the plan in the court?
Yes, Section 113 of the 2004 Act provides that opportunity. I don't know.
Presumably that's within 6 weeks in the normal way, is it?
Yes. We have not produced it, but there is that provision, Section 113 of the Act.
So anyone who says that it doesn't comply with these elaborate requirements has their chance to challenge it within 6 weeks, and if they don't, it's presumed valid.
Yes. Well, the challenge is on what will be, for my lord, the familiar grounds, not within the powers and so on.
That's section 113.
113. So just pausing there with the statute, a very elaborate statutory code designed to allow intervention by the Secretary of State, participation by local people, and for those who don't like the result, the opportunity for challenge, all signalling how signally important that the plan is in the process. May I secondly go to tab 3 of the same authorities bundle. Tab 3 is the regulations, the town and country planning, local planning regulations. And if my lords would go, first of all, to page 941. This is simply to deal with the point I referred to earlier, what's a local development document? And here it is, what's included within it. And then if you would, to page 948, which is part 6, local plans, regulation 17 and following, through to regulation 31, a suite of elaborate regulations, including, for example, regulations about, at page 953, independent examination, and the publication of the report, adoption, and so on. Elaborate regulations, again, fully supporting what was given by way of a description, Lord Reid, of the way in which local plans are prepared. My lords, also by way of an indication, and this is the third matter, the statute, rules, and the third matter is the importance of local plans, the simple breadth of them in terms of the matters that they are covered, the range of matters that are addressed. And we might illustrate this, I hope, conveniently by taking up the authorities, volume 4B, and looking, in order to illustrate the point, at page 2253. Which I hope is simply the contents page, and I use it simply as a convenient way of indicating what the breadth of a local plan might be in practical terms. I won't excite your lordships over much by going through the individual chapters, but I do invite consideration of the breadth and...
You're relying on the list of contents?
Yes.
Thank you.
As an indication of what's involved. And then, if you would, to deal with the Suffolk plan in the same volume at tab 51.
Thank you.
And
that's the same stuff, is it?
I beg your pardon?
That's the same stuff, is it?
Well, it's the same stuff. It's just differently expressed. And it's differently expressed at page 2403. And I'd draw attention to it, not to duplicate what I've said about breadth from the Crewe and Nantwich plan, but to take my Lord Carnwell's point, this is a more up-to-date plan. And if you look at paragraph 126 on page 2403, and the box underneath it, you begin to pick up some of the flavour of the breadth of matters that a local plan is covering. If a more articulated explanation is helpful, if you go to page 2553, you should have on page 2553 in a landscape format, a policy overview
Yes.
And I simply invite your lordships to note the
It's
range.
really the second column of DM1 and so on, is that?
Well, it's all relative, relevant. Strategic policies are in the middle column,
Yes, I
development
see.
management policies the right.
I see
Simply
flood
at-
risk, biodiversity, climate change,
all,
etc.
yes,
Yeah,
all
okay.
the whole lot.
I think we do have the point.
Good. Well, the only other point from this, which might be relevant at a later stage, is to note the way in which the policies are divided. In relation to objectives, sustainability
Yep,
embraces SP 19 through to 29.
yes,
So these are sustainability policies in the plan's term, not housing policies. And in relation to housing, objective 2, housing growth, SP2. And that at least is the way the plan explained itself without apparently any objection from anyone when it did so. My lords, to put the matter by way of summary, the local development plan is a spatial plan. These are not simply generic policies dealing with particular issues, but policies which, unlike the national policies, are shaped by local circumstances and priorities in exactly the way that the framework promotes. Yeah. And I've drawn your attention to paragraph 150 from the framework. There are a whole range of paragraphs we could have looked at for the same point, but 150 is convenient. Shaping vision, local priorities, and so on. My lords, we have earlier pointed out that the framework, important as it is an other material consideration. One here possibly contentious issue that's arisen is our desire to make clear that when the government produced the framework, it made a deliberate choice with regard to the status of the framework and whether it should have statutory force, and by that means take precedence over the development plan in any defined circumstances. They had the choice as to whether it should rank alongside the development plan as an equal, or whether it should remain as simply another material consideration to be taken into account as a policy statement in a familiar way. The material which we wish to rely on is contained in the authorities volume 4A. My learned friends do not agree that this material is relevant. In essence, what we wish to refer to is the House of Commons National Planning Policy Framework 8th report, which records the government's position, and we rely on it as recording the government's position.
yeah.
And
Page?
it starts at page 1934,
Yes, it does.
and the relevant part from our point of view is at page 1975. We draw attention to what is recorded as being a statement of the Minister at paragraph 100 on page 1976. Paragraph 100, in a debate on the Minister said, the first objective is to make local plans central to what happens, transfer power to local communities. That has to be crucial. And then in the same paragraph, after a reference to the Minister giving assurance that the primacy of the local plan would remain, Mr. Clark continued, as far as the default yes goes, the principal default is in favour of the local plan. It's very important that we took a decision there. When the localism bill was going through, there was an opportunity to change the basis of planning law, section 38.6 of the 2004 Act, and we didn't do it. So, my lords, a deliberate choice not to change.
So this is relying on a statement made in Parliament
Yes.
after the bill's become an act, about the act. That within pepper and heart.
Yes.
It's about the policy.
No, it's about the policy, this is, my lord, not about the Act. This is about the Secretary of State. This is the Secretary of State explaining what he was doing when he produced the policy in the framework.
I mean, it's obvious from the Act that he didn't. I mean,
Yes,
Well, it
we've
is.
seen that.
yes.
And of course, this was all part of the sort of localism, which is very much a sort of central part of government policy there, wasn't it?
Yes.
Putting power to back to the community, as it was said,
Precisely.
decentralising and so on.
The Minister continued, it follows from everything I've said so far that the most important basis for a decision is the local plan. I want to say more of planning and so on. you can see at the bottom of that page, the committee recommended that the framework unambiguously reflect the statutory supremacy. That became recommendation 18 in the committee's recommendations. You can see that at page 2003.
Yes,
Recommendation 18.
yes.
In due course, the government responded. Recommendation 18, statutory status of local
Yes,
plan.
yes, we've seen that.
The government responded to that report, page 2177,
Yes,
and we draw attention to the following matters from that response. Page 2180,
yeah,
and paragraph 5, the last sentence. We've made changes to provide certainty about the relationship between the framework and the legal framework for planning set out in the Planning Acts. At page 2183, paragraph 12, government agrees that it should be clear that local plans can reflect issues that are not explicitly referred to. Consistent with this, government's commitment to putting locally led planning at the heart of the planning system must make clear local plans, and you'll see the quotation there. And then page 2186, and this was important because there was a lot of concern as to whether the default answer was yes, in other words, development would go ahead, whatever. At paragraph 27, the government accepts the recommendation the default answer is yes should be removed. The language has given rise to unwarranted concerns that development should be allowed to proceed at all costs, which was never the intention of government policy. Remains committed to ensuring the planning system does everything it can to support economic growth. Paragraph 28, we've amended the framework to be clear planning should not simply be about scrutiny, creative exercising, finding ways to enhance and improve the places in which people live their lives. And then importantly, paragraph 29, however, we've also revised the framework to be clear that economic growth will not be at the expense of the countryside and heritage that we value. Paragraphs 30 and 31, 31 is important. We've clarified the presumption in favour of sustainable development to remove any ambiguity about the fact that it operates within this legislative framework and supports the delivery of strong and up-to-date local plans.
this reflects, all this is now reflected in the framework.
Is intended to be reflected in the framework, and on our interpretation of it, would be faithfully reflected in the framework, because our interpretation is one which does not have a development at all costs sort of approach.
So all this is a question of construction of the framework.
Yeah.
Yeah, it is. And all of this that we're referring to here is, I respectfully submit, firmly within the ambit of what was being referred to in Adedoyan. That is what the minister was saying about his policy and what it was intended to achieve. And it reflects the same approach taken by the Court of Appeal and Lord Justice Sullivan in Red Hill. The final document...
This comes later. I mean, we've looked at the 2004 Act, and you attach importance, I think, to the fact that the 2004 Act is a much, much more elaborate code than we had before, and we get away from the very simple concept of a development plan, which was what I was used to back in the mists of time.
What a pleasure that
fairly
is.
elaborate sort of collection of documents with a very strict process for approving them and a very clear role for national policy. And we also get in section 38.6 the reinforcement of the point that the presumption is in favour of the development plan, which we didn't have before.
But precisely so, and built into that elaborate 2004 Act framework, this engagement with, say, statements of community involvement, the right to be heard and so on, are all consistent with what my Lord has referred to, effectively, the government's localism agenda. Let me take up the last document, which is tab 49 in the same bundle. This is the statement the Minister made to Parliament, and therefore in as it were, Adedoyan territory when the framework was published, 27th of March 2012. You can see from page 2250. If you go to page 2251, can I ask you to note, please, without me reading through it, the first complete paragraph and the reference to detraction from character of areas, many of our habitats downgraded and so on. To the second complete paragraph, the reference to local plans being the keystone of the planning system, and the aim of the framework being the planning should be much simpler and more accessible, removing the impenetrable jargon. Then under the column 1338 reference...
It's reduced to a few simple documents like this.
That's at least the third statement that's been made, that shortness and simplicity have not necessarily aided clarity, I think was Sir David Keene's statement in Hunston. But then under 1338, could you note, please, in the third line, the framework guarantees robust protections for our natural and historic environment.
I'm so sorry, which page are you reading from now?
2251, my lord.
Yeah.
The break, just below 27th of March, column 33, 1338.
Just below 1338.
Sorry, thank you, yeah.
Third line, guarantees robust protections. The next paragraph, lots of debates about this, and the relevance of that will emerge in a moment. End of that paragraph, keystone of the planning edifice, local plans. And then the final paragraph on that page, and this is some 4 lines down, it makes explicit, that is the framework, makes explicit that the presumption in favour of sustainable development works through, not against, local plans. It makes clear that relevant policies, and that wording might just be important, relevant policies such as those protecting the Greenbelt, sites of special scientific interest, national parks and other areas cannot be overridden by the presumption. It recognises, and the language I'll return to in a moment, recognises the intrinsic value and beauty of the countryside, whether specifically designated or not. The rest, my lords, can see. Then, if you would, at page 2252, and under the reference at column 1339, finally, this House has a particular role to play in safeguarding the interests of our successors. I will ensure that Parliament, having shaped the development of the new framework, supervises the implementation of the policies, starting with the debate on the floor of the House soon after we return from the Easter recess. So this is, from my point of view, our submissions, flagging up the importance of what we're reading as to what the Minister was saying to Parliament, because he was saying in terms, I want there to be a parliamentary engagement in this process. I'm not, as it were, just politely telling you I've produced it. My lords, all of that material, we say, supports the view that the framework was of itself not intended to either effectively displace or downgrade the statutory development plan.
Normally, we look at what's said in Parliament to see what Parliament thought it was doing.
No, my lord, I'm looking...
But in this case, it's just the Minister speaking to Parliament and they don't do anything, is that right? It's merely he's telling Parliament what he's doing.
He did.
They're not going on to vote on anything or approve anything.
There was a subsequent debate, and
No, never mind about that, but there's nothing that they actually do, like approve a statutory instrument or pass a statute.
No, nothing of that kind.
Right.
This is in the, for shorthand, Adedoyan category of the Minister being, we all agree, entitled to do something, produce a policy, and explaining to Parliament what his policy is intended to do, what it's intended to achieve. And our submission is consistent with what Lord Justice Ricks thought, and indeed in principle with what Lord Justice Sullivan did in the Red Hill case, is that this is material which is relevant, because it allows you to see what the Minister intended should happen. So, my lords, nothing here which we submit should in any way erode the protection local plans provide for the environment, including the intrinsic value of the countryside. To the contrary, we submit the language makes plain the framework is intended to support local plans whose policies are consistent with the framework's approach. The alternative course of changing planning law rejected in favour of that approach, which I've instanced at paragraph 17 and the first bullet point of the framework, the first core principle, rejected in favour of an approach which makes the system genuinely plan-led, empowering local people to shape their surroundings and so on. Any approach, my lords, to the interpretation of the framework we submit should respect the statutory framework, not allow the framework to displace or downgrade it, not allow it, in effect, to see the development plan's policies put to one side, and put to one side in favour of a national framework which is not spatially significant. The key point about local plans, their spatial significance, the way in which local people have been allowed in them to shape their surroundings. My lords, I turn then from the statutory context to the context of the framework taken as a whole, that is, looking at the whole document. It's important in this regard to take the point, as it were, the reverse of the point I've just made, that the framework is, of course, not a spatial plan. It's necessarily not spatially specific. It provides generic policy direction, necessarily and obviously to be contrasted with a spatially specific approach. As a part of the context for a construction of any part of the framework, we draw attention to the following matters, and if I may, I'll take them. I've referred to some of them already. I take them briefly from the framework, so we're in the appendix, part 2. And in support of the submission I've made about this as the context, page 212 and paragraph 1, in particular the last sentence of paragraph 1, paragraph 10 on page 214, plans and decisions need to take local circumstances into account so that they respond to different opportunities for achieving sustainable development in different areas. It is not, in other words, the government intention that there should be a one-size-fits-all approach. I've already drawn attention to paragraph 17.1, and don't do so again. If we could go then to paragraph 47 on page 223. Yep. Page 223, there should be a heading above paragraph 47.
We see it's vestiges.
Well, it should say 6, delivering a wide choice of high-quality homes.
Delivering a
I beg pardon?
range of high-quality homes.
Delivering a wide choice
of
high-quality homes.
But not of high-quality typeface, it appears.
No,
Yep,
or in this case, printing. But 47, and I'm going to read it all, but the first bullet point is curiously important. To boost significantly the supply of housing, local planning authorities should, so quite clear, boost significantly the supply, but use their evidence base to ensure that their local plans meet the full objectively assessed needs for market and affordable housing in the housing market area. Lots of my learned friends' written cases stop at that point. There is one exception. The Secretary of State, in his recital of the framework, recital only, continues. But my Lord should note, unlike my learned friends, that the bullet point continues as far as is consistent with the policies set out in this framework, including identifying key sites which are critical to the delivery of the housing strategy. Those words, as far as is consistent with the policies set out in the framework, are qualifying the requirement to meet the full objectively assessed needs. So you assess what those needs are, of course. But there is then the qualification, and it's an important qualification, to note. Then paragraph 150, a paragraph to which I've already referred and simply in this context ask you to note again. Paragraph 154, local plans should be aspirational but realistic. They should address the spatial implications of economic, social and environmental change. And that reference to economic, social and environmental change is a cross-reference to what's involved in sustainable development and referred to at paragraph 7, if you just turn back to page 213. 3 dimensions to sustainable development: economic, social, and environment. They're there set out. So those are the dimensions. Paragraph 154, what should local plans do? Address the spatial implications of all 3 elements. And then, my Lords, 157, which is introduced in this way: crucially, local plans should, and the first bullet point, plan positively for the development and infrastructure required in the area to meet the objectives, principles and policies of the framework. Then a range of others, but please note the penultimate point: identify land where development would be inappropriate, for instance, because of its environmental or historic significance. So it is explicitly crucial, a crucial role of local plans that they should do that. My Lords, we've noted earlier that in order to be adopted, plans had to be sound, and I've drawn your attention to paragraph 182. The only matter to add, or perhaps to emphasise in this context, is that the framework requires that policies in plans should be supported by an adequate evidence base, and it's the examiner's job to consider that. That's what he's being told to do. Is there evidence to support the approach? And if the policy makes it over the line, then the evidence base has been judged adequate, the plan gets into the sound category. My Lords, all of this in the context of the government's desire to ensure that planning policy should be simple and clearly expressed, rooted in local communities, and affording the opportunity for them to have and see expressed in the local plan their priorities and a local vision. It is not intended to be, my Lords, on any fair reading of the framework, a top-down planning approach. The clear requirement for authorities, as we saw by way of example from paragraph 157, crucial requirement to deal with land where development should be restricted because of value, all a part of that, and seamlessly linking with paragraph 182, where it's reasonable to do so. That qualification in paragraph 182, all, of course, in the context of the definition of sustainable development. The end result, local plans as a deliberate consequence of the statutory framework and the government's approach, establishing a series of local choices fuelled by a local and very specific evidence base. That means that, for example, the boundaries of areas which are considered important to keep open so as to preserve the separate identities of settlements are not, we submit, boundaries which are to be regarded as simply the concomitant of provision made for housing. Rather, they are properly to be regarded as the reflection of local choices and priorities embodied in the development plan as to what is locally important. That the breadth of topics covered by the development plan means that there will be a whole range of issues where this spatially specific, locally evidence approach will have been taken. They will cover greenbelts, areas of outstanding natural beauty, heritage issues, ecology, nature conservation issues, landscape, jobs, employment, leisure, recreation. The framework itself, of course, deals at a generic level, as my Lords will be able to see, with those individual topics. But the framework makes clear that even in its generic approach to the policy issues, the need for housing will not automatically override these other considerations. For that, we might just look back to the framework in the appendix And on this occasion, page 215, paragraph 14 is really a very important paragraph. You'll see it starts with, at the heart of the national planning policy framework is a presumption in favour of sustainable development. My lords have seen what that is from paragraph 7. Seen as a golden thread running through plan making and decision taking. For plan making, this means that, and you'll see the 2 bullet points, local plan, the second one, local plans should meet objectively assessed needs with sufficient flexibility to adapt to rapid change unless, and then adverse impacts, or specific policies in this framework in development should be restricted. And there's then a footnote. And the specific indication of not develop is given not as an inclusive list, but as examples. For example, these policies relating to sites protected under Birds and Habitats Directive and or designated as sites of special scientific interest, land designated as a greenbelt, local green space, an area of outstanding natural beauty, heritage coast, within a national park or Broads Authority, designated heritage assets, and locations at risk of flooding or coastal erosion. There are others, but those are the examples that are given. The same applies for decision-taking. My lords will see, approving, and I'll come back to this a little later on in more detail, approved development proposals accord with the development plan without delay, where development plan absent, silent, or relevant policies are out of date, grant permission unless, and one of the indications of not granting permission is specific policies in the framework indicate development should be restricted. And the same footnote 9. There is, in other words, my lords, in this part of the framework, in the government's approach, no indication that housing, or indeed, because paragraph 14 applies to all development needs, housing trumps these other environmental considerations. And we've noted that the Secretary of State's written case, paragraph 107, accepts that approach. Such an approach is entirely consistent with the framework when read as a whole. The framework pursues sustainable development. I've also seen that defined at paragraph 7. It pursues it in the context of paragraph 6, telling us that the purpose of the planning system is to contribute to the achievement of sustainable development. The policies in paragraphs 18 to 219, taken as a whole, constitute the government's view of what sustainable development in England means in practice for the planning system. So the 3 dimensions of paragraph 7, then differently expressed in the different policies of the framework. So this is to be read as a whole, and taken as a whole, we submit absolutely no indication that any one element should rule the day in any particular circumstances. We have noted the respondents' references to the framework's approach to housing and the reference to it being the only element that has the 5-year calculation and the deeming provision of paragraph 49. I can say that that is correct. But that, of course, is simply because other policy considerations are not susceptible to that sort of mathematical calculation. Housing need is. It's capable of being assessed on a basis which allows one to consider population and the like. The Secretary of State, in his written case at paragraph 61, relies on the reference to a radical change having taken place with the production of the framework, and he draws on the authority of Gallagher. My lords, you might, if you would, take it up. It's in the Authorities, Volume 1.
Yep.
And at tab 8, this was a case all about the Solihull local plan and whether or not the inspector had got it right in the assessment of housing needs. I don't, for my purposes, need any other explanation, but if your lordships would go to paragraph 16,
Thank you.
which is the paragraph relied on as supporting the radical change in the Secretary of State's written case.
This is on page 1061.
It is, I beg your pardon, it's at 1061, paragraph 16.
Thank you.
Having the judgment having quoted the judgment below quite extensively, Lord Justice Laws went on at paragraph 16 to refer to the reasoning being correct, supported by the language of paragraph 47, reflects the construction of paragraph 47 given by the court in Hunston, and binds us. The MPPF indeed effected a radical change, and that's what the Secretary of State refers to. It consisted in a two-step approach, which paragraph 47 enjoined. The previous positive methodology was essentially the striking of a balance. By contrast, paragraph 47 required the OAN to be made first, given effect in the local plan, save only to the extent it be inconsistent with the other framework policies.
What is OAN?
Paragraph 16.
Sorry, OAN is what?
Objectively assessed need. I beg your pardon. Objectively assessed need.
Why does he say that was a radical change from what happened before?
Because previously the approach had been one which involved effectively a balanced approach. What the framework did, and what paragraph 47 invites, is, not invites, requires, the court has said in Hunston, which is quoted here, that there should first of all be an assessment of the full objectively assessed need for housing, and that as a distinct exercise. When you've done that, you may then consider the extent to which, consistent with the other policies in the framework, that need should be met. And the radical change which is being identified here is that first step in which the full objectively assessed need has to be set out, and that was the inspector's error in essence in Solihull, and then consideration given as to whether or not it should be met, applying the other policies in the framework.
It does surprise me that that's such a radical change.
Well, some would agree with you.
Quite a lot.
Well, my lords, the Secretary of State thinks it was radical, and Mr. Philpott will tell us all about why he thinks that in due course. But from my point of view, I simply point out that the radical change here makes not a jot of difference.
Anyway, in 47, the radical change, if it be such, is in the preparation of the local plan.
It was in the preparation of the local plan to assess the objectively assessed needs.
Not in relation to what you do having got your local plan.
No, not at all. But the Secretary of State uses the point in order to say that the framework is somehow giving housing a priority. And our submission is that it simply doesn't. Yes, housing is important. Yes, boosts significantly. But the framework is nowhere signalling that housing trumps any other need. And we should note in that connection that when the framework wants to say that great weight should be given to something, that is, particular significance given to it, it does say. And without, I hope, being unduly tedious, you can see that in a number of different places in the framework's language, for example, with regard to the Greenbelt at paragraph 79, page 230. With regard to mineral planning applications at page 245, paragraph 144, when determining planning applications, local planning authorities should give great weight. So when it wants to say great weight, it does. And, of course, there is boost significantly, but no more than that. None of the respondents, including the Secretary of State, make any submission that any particular element of the framework is intended to override any other element. In other words, we don't see a submission from them which is explicit in terms of the trumping. And if there was to be any such trump card in the form of housing, I respectfully submit one would expect to see it spelt out in clear terms rather than being the product of some mental gymnastics. And I bear in mind here that the framework says that it's intended to be simple, clearly understood by non-experts, not needing a philosopher to guide you through it. My Lords, I move to paragraph 49, and now specifically in the context of section 6 of the framework. For this, we need the framework again, and page 224 of the appendix part 2. We've got to a position where we've got the framework in the context of what the government was saying it intended. We've looked at the statutory context. We've looked at the framework as a whole. And we're now, as it were, focusing on the particular section which contains paragraph 49. Section 6 at page 223, as I've already noted, starts with paragraph 47. And I've already drawn your attention in the first bullet point to the fact that although there is, of course, the reference to objectively assessed needs for market and affordable housing, it is to be provided as far as is consistent with the policies in the framework. And that, as we said, is the caveat right at the beginning. So as an immediate context for the construction of the paragraph 49, the framework is making it clear that boosting significantly the supply of housing is not at all costs approach. That, as it happens, is reassuringly consistent with everything the Minister said to Parliament when introducing the framework. And those references I've given you already. I remind you, the government made it clear that the pursuit of economic growth would, and I quote, not be at the expense of the countryside and heritage we value. That's in Authorities Bundle 4A, page 2187, and paragraph 29. Paragraph 49 starts with emphasis on the presumption in favour of sustainable development. In other words, we're starting not just with how do we provide more houses, but an emphasis on sustainable development, that is, economic, social, and environmental roles. There's nothing there in the opening sentence of paragraph 49 which is heralding an approach which might lead to sweeping away or watering down any spatially specific element which is addressing those other considerations, environmental and social. Paragraph 49 continues.
Does the document make that clear?
I mean,
does it define sustainable development?
Paragraph 49 is...
Yes, paragraph 7.
Paragraph 7 defines sustainable development, my Lord. Page 213 and paragraph 6 and 7. So right at the beginning of paragraph 49, we're being told, although we're boosting or looking to boost significantly the supply of housing, we're doing so in the context of what's sustainable. And what's sustainable embraces something other than just building houses. Paragraph 49 continues with the reference to relevant policies for the supply of housing. No one disputes here that relevant policies are the policies relevant to the consideration of a particular planning application which is being considered. No issue. They are required, however, to be for the supply of housing. It's those words that have proved troublesome in this context and have led, of course, to the different views as to whether a wide or narrow interpretation of the for the supply of housing wording should be used. My Lords, before I turn further in the framework, I'd like to deal with the issue of the natural and ordinary meaning of the words for the supply of housing. They're used here, we submit, as words of limitation. So relevant policies, which are going to be considered to be not up to date, relevant policies for the supply of housing. Those words of limitation, it could have said all relevant policies, or as Mrs. Justice Lang said, it might have used an alternative wording, and for this you need the appendix part 1.
One can always play games about what it could have said. that both sides can play that game. It
Well,
doesn't really help. You've got to take it what it says.
Well, precisely so. But when we're told that this language is intended to be plain and simple, we find, and this is Appendix 1, page 44.
Yeah.
This is Justice Lang, paragraph 51. Here we see the judge giving her view of the natural meaning of the words. And to borrow my Lord's expression, she played the game of saying, well, there are many such policies in local plans. Paragraph 49 could have been worded so as to read policies which may restrict housing development or policies affecting housing development, in which case it would have been a broader scope. Simple words, but different approaches to their construction. In reaching the conclusion, the Court of Appeal found that the words mean policies affecting the supply of housing by restricting the locations where new housing may be developed. And that is taken from the Court of Appeal's judgment in the same Part 1 of the appendix, paragraph 33. My Lords, if you could take that up. Because it's clear from paragraph 33 what the Court had in mind, the Court of Appeal, that is, had in mind. It said at the end of paragraph 32, it thought its construction was, as it were, interpreting the policy in a straightforward way. But in paragraph 33 and 4 lines in, that is, that interpretation recognises that the concept extends to planned policies whose effect is to influence the supply of housing land by restricting the locations where new housing may be developed. And then there are a list of examples given. And these, my Lords, are read as examples of policies for the supply of housing. So the Court of Appeal's view, policies for the supply of housing include policies for the green belt, policies for the general protection of the countryside, policies for conserving the landscape of areas of outstanding natural beauty and national parks, policies for the conservation of wildlife or cultural heritage, and various policies whose purpose is to protect the local environment in one way or another.
So effectively everything is a policy.
Yes, more or less, my Lord. Anything which might affect it, anything which might restrict it.
I mean, if one looks, I was wondering whether one gets any help by looking at the list that you showed us at paragraph 157 on page 249. That sort of categorises the things one expects to find in the local plan.
Yes.
Clearly, some of those are dealing with planning positively for development, to housing. But then you get down to aspects which are identifying land where development would be inappropriate.
Yes.
Now, looking at that, one wouldn't have said, well, that's a policy for the supply of housing. But the Court of Appeal say, yes, it is, because it affects it and therefore restricts it.
The Court of Appeal's view, because it would restrict where housing could go, everything that might have been done as a consequence of the local authority undertaking the crucial exercise of identifying land where development would be inappropriate. In the Court of Appeal's view, that produced a policy for the supply of housing. My Lords, I respectfully submit that is a startling conclusion.
Well, if you had a local plan which covered an area, almost all of which was green belt, and it said no building on the green belt, it wouldn't be particularly surprising if you regarded that as part of the overall, one of the aspects of policies in relation to housing, a policy for.
Relating to, clearly.
Yes, but it would be a bit odd if you couldn't take it into account when considering this paragraph.
Related is...
I know, but just looking at the purpose of the paragraph rather than playing with words.
Yeah, well, my Lords, I'm not keen to play with words. I'm adopting...
I know you are, but just concentrate on the question. If you had an area, local authority, which very, very large part was green, was not built on, was parkland, whatever you like to call it, and there was a policy saying no building on this green land, which very, very much restricted the area which any housing or any other building could go on. You'd say that shouldn't be taken into account on paragraph 49?
It would not be a policy for the supply of housing. The policy would be taken into account in a consideration of the application. And if there was...
It would be obvious that it had to be taken into account, yes?
Well, it would be a policy of the development plan, my lord, that would be taken into account. And the exercise that would be gone through would not be to denigrate the housing need,
No, I have not.
but to respect the fact that the development plan had said this is Greenbelt with a particular value, Greenbelt purposes, as per the framework's policies. I'd ought to be familiar with them. But then have the opportunity in the decision-making process of saying, but there is a particularly acute shortage of housing. So we are going to balance.
Yes, my lord refers to the purpose. This has a rather odd purpose of deeming something to be out of date.
Yes.
Which may not be. Where you've got a recently approved Greenbelt policy, which has been approved under the process we've looked at, and where the Secretary of State hasn't intervened to say it's contrary to his policy. It seems a bit odd that you can then say, well, that's out of date, because you haven't got a 5-year supply. You can obviously take it into account.
Yes.
But the question is whether it's whether it's one of the policies for the supply of housing.
Let me just take it a stage further. If the Court of Appeal is right, policies, A and B, Greenbelt, all these policies listed, paragraph 33, are policies for the supply of housing. Any such policy in the development plan will then be deemed to be out of date. You go then to paragraph 14 to make your decision. So we've got the deeming in place. Go to paragraph 14, decision taking. Where development plan is absent, silent, or relevant policies are out of date. There is the link to paragraph 49. Relevant policies out of date. Grant planning permission unless. So all these policies the Court of Appeal says to be regarded as out of date because of the deeming provision. Get to paragraph 49, grant planning permission unless, and the second indent under the second bullet point, unless specific policies in the framework indicate development should be restricted. So here is the don't do it if. And then, my lord, should compare the list at footnote 9 with the list of policies in paragraph 33 of the Court of Appeal's judgment, from which it is perfectly apparent that there is a significant overlap. So if the Court of Appeal is right, what happens is all of these are policies for the supply of housing. They are to be regarded as out of date, with the implication, as the Court accepted, they might get less weight. We move to paragraph 14 and go through the decision-making process, only to find that although the development plan policies with regard to, for example, areas of outstanding natural beauty are to be regarded as out of date, suddenly the framework is telling us, no. The policies in the framework in relation to areas of outstanding natural beauty should be taken into account as an indication of not granting planning permission. My lords, two things are happening there. One is the carefully considered, spatially applied policies in the development plan are being rendered out of date, only then to find that they are replaced by the footnote 9 process with generically non-spatially specific policies from the framework. By that process, the framework's general policy has replaced the development plan policy in terms of an indicator. Now, my lords, as a matter of approach in the context of the statutory scheme, I respectfully submit that that is wrong.
Well, I wonder if I could ask you one thing about that, if I may.
Yes.
Footnote 9 and paragraph 14 gives as an example of specific policies indicating development should be restricted, land designated as greenbelt. That is a reference to, presumably, the spatially identified greenbelt by the local authority.
Well,
What else can it be?
well, except that greenbelts in development plans are sometimes designated generally in boundaries defined at different stages of the development plan, and it would depend at what stage the particular development plan was that was being considered.
But you spoke about generic policies. I mean, how can the framework have a generic policy for greenbelt in a particular locality other than by reference to that which the local plan has defined?
It depends to what degree of particularity the local plan in play has descended in the definition of the greenbelt, whether it has done it by reference to specific boundaries or a more general designation with the boundaries then to be defined specifically in a subsequent development plan document.
I make the same point about designated heritage assets. I mean, is it not a reference to the local, what the local plan has said?
No, my lord, in that case it isn't, because the local plan will have contained not only a list of the designated assets, but will have contained, or will typically contain, policies which will relate to controls for development, which will have been shaped by the circumstances of the area. So, for example, in an area where there's a significant urban concentration and there are assets within the designated heritage assets within the urban area, a different approach might be taken in the local plan policies to assets which were in a countryside area where different considerations might apply, for example, with regard to setting, which is an important consideration when looking at the impact of development on heritage assets.
Can you tell me how this works in practice? The inspector is sitting here with paragraph 49 in front of him, and the planning officer says, sorry, we don't have a 5-year supply. Can't do it. We just don't have it. And the inspector said, well, where are you going to get the sites in order to achieve the 5-year supply? And they say, well, every other site we've looked at falls foul of some environmental policy. So it's a complete stymie. What is to be done?
What is to be done is what has been done for very many years, which is for the decision maker to weigh, quintessentially a decision maker process, weigh the different considerations that are in play. The development plan policy which restricts development in this area for reasons related to its environmental value. There is the policy. It's up to date in the sense that nothing has eroded what contributed to the formulation of the policy. On the other hand, I have a housing need, and typically the decision maker would say, what's the extent of the need? How far short of a 5-year supply are you in this particular case? Is there some particular issue about the type of housing to be provided? Has there been a long history?
I mean, you can't really just point to the two decisions we have here, although I know you may not want to do that. I mean,
No,
they illustrate on one view, one inspector saying that on balance, the need for housing, although he acknowledged it was outweighed for this particular site by other considerations. On the other, he decided that it wasn't. And I know you're going to try and say that one is right and one is wrong, but I mean, on one view, you've got two perfectly conventional decisions by inspectors weighing up the policy, the need for housing against the other considerations.
Well, that's right, but the process is important here, and particularly the process with regard to what you do with the development plan policies on the way to that conclusion. In the one decision here in Cheshire, the inspector said NE2, NE4 and RES5 are policies for the supply of housing, and in one way or another, I'm going to...
But he said a bit more than that. He said also that he thought that on their merits they were outweighed by the need for housing.
Outweighed, but The effect of that is, from the local authorities' point of view, to make the exercise which they've gone through, paragraph 17, first bullet point, paragraph 1.157, penultimate bullet point, make that exercise rather less than useful. And in terms of delivering, my Lord referred to the localism agenda, something that engages local people, telling them that, for example, a policy which has designated a green gap, which is important to preserve separate community identity, telling them that's a policy for the supply of housing is, from the point of view of engagement with the planning process, a disaster, because it effectively means that in the process housing has trumped all other considerations. And nothing prevents, to answer my Lord's question, nothing prevents the decision maker breaking the stymied position by a weighing approach. He simply has to say, in my view, the housing need here is sufficiently significant that it outweighs these environmental or social or other considerations that have driven these other policies. But to get there by way of a route which creates a fiction around a policy which may be still as up to date in terms of the evidence that supported as it was at the date of adoption is not correct, does not respect the statutory scheme in the way that we have identified. And we could take it here, by looking specifically at one of the policies. Let's take NE2, which is one of the Cheshire East policies. My Lords, you have it in Authorities Bundle 4B. At page 2267 in tab 50.
Yep.
The respondents, in common with the inspector, say this is a policy for the supply of housing, and in effect, the boundaries which have been designated as the open countryside boundaries are the concomitant of the housing need which existed at the time when this rather older plan was being adopted. There are, we respectfully submit, a number of matters which are incorrect in that approach. The first is that this policy is not simply a concomitant policy. Planning policy has for a long time protected the countryside for its own sake. And you can see that if you look at page 2267, paragraph 412. The justification for the policy refers to some earlier planning policy guidance. Still seeks, the last two lines on page 2267, planning policy still seeks to safeguard the countryside for its own sake through specifying diversification of the rural economy is also required. The framework now puts it slightly differently. The framework puts it in paragraph 17 in the fifth bullet point, page 216 of Appendix Part 2, as one of the 12 principles is take account of the different role and character of different areas, promoting the vitality of our main urban areas, protecting the green belts around them, recognising the intrinsic character and beauty of the countryside, and supporting thriving rural communities within it. So, first point is this is not a concomitant policy. It's a policy which has an objective, which is for its own sake, or for its intrinsic beauty, we protect the countryside. Secondly, the submission that this is simply to be regarded as a concomitant of the housing numbers ignores the fact that in the preparation of local plans, local authorities and local people contributing to them will have made choices. They will, for example, have made choices about what development should take place within urban areas on what sites. They will have made choices as to whether land in the urban area should be used as for housing or for some other use. They will have made choices about the density at which development should be undertaken, choices about whether or not land should be reserved for a particular purpose. All of that, quite consistent with the approach in the statute and in the framework's policy of saying this is about local choices and vision. So it isn't, as it were, a necessary concomitant that as soon as you say there's more housing, then we've got to have more countryside taken, because there is that whole area of choice that local authorities have to undertake. Thirdly, our approach to the countryside policies and the value of the countryside and protection of the countryside, and not regarding any two as policies for the supply of housing, is entirely consistent with the Minister's statements to Parliament made when the framework was being launched, and with the government's response to the Select Committee's approach. There is nowhere an indication that the countryside was not to be valued for its own sake, rather than as some sort of, well, if you're not going to put houses or development on it, you must call it countryside. My Lords, those considerations mean, I respectfully submit, that you simply can't say that NE2 is the concomitant of the housing number, whatever it might have been, when the local plan here was adopted. And to the extent that my own friends rely on what the inspector said in that instance, we might just look at his decision letter, which is in the appendix, part 1, and it starts at page 49. You'll see land north of Moorfields, and Moorfields you've had identified for you on the plan. But it's important to see what the inspector said when he was considering, in the part of his decision letter, issue 2, which starts at page 53, paragraph 25. Paragraph 32 on page 54. It is yet to be established fully what land, if any, outside settlement boundaries and hence subject to this policy will be needed for development to meet current and future housing needs. So the inspector is flagging up for us that at the stage he's considering it, and it's his wording, yet to be established fully what land, if any, outside settlement boundaries. Now, the appellants drew attention to the fact that there were proposals to remove some land in another location.
I mean, he was dealing with a case where the development plan was clearly out of date, and there was an emerging plan. So he clearly had to do something to deal with the problem of the housing need.
Yes, and the way...
One goes to paragraph 94, 95, although he sort of pays lip service to the idea of asking whether it's a policy for supply, what he actually does is look at it in the conventional way in terms of the weight to be given and the physical effect on the land.
Well, my Lord says he pays lip service to it being a policy which is out of date. That is quite in the context of a statutory scheme that says development plan first. It's important...
Except this was a pre-2004 Act plan, wasn't it?
Precisely so.
I mean, it was fairly out of date. So.
Well, no, but with respect, no. Age is... it's reassuring for some of us, at least, that age is not...
So you're out of date.
Age, my Lord, is not a parallel for being out of date, and so the court has told us in the Daventry case referred to in the authorities. So the age of the policy is not a consideration. With the housing policies here, the numbers were clearly out.
So what I'm putting to you is that although, because that's what the cases say, he had to go through this exercise of saying, if this is a policy for supplying housing, this is not, and he uses the word out of date. If you would actually look in practical terms at what he did, it was perfectly conventional, sizing up of the need for development against the impact of these particular proposals on the policies.
And if he'd adopted an approach which had said, I recognise that these are policies which have a particular purpose to protect the countryside or protect the green gap between Williston and Rope, I've weighed those policies and the extent to which...
he says that, paragraph 95. It
yes.
would physically erode the green gap between Williston and Rope, contrary to policy S4, although only to a limited degree, and there would be no significant harm to the wider function of the gap.
Precisely.
Absolutely conventional.
But starting from a premise that the policy is to be given less weight because it's a policy for the supply of housing.
Or because it's 10 years old.
Well, that with respect, is exactly the point that age, with regard to these policies, is not the relevant consideration. I do not dispute that the inspector could have reached the same conclusion if he had given the development plan policies the weight that they should have been given and not regarded them as policies for the supply of housing. That was clearly, as I've said already in answer to my Lord Gill's question, clearly an approach which was open to him. It's a simple weighing exercise. My Lord says he went through a conventional weighing exercise. In one sense he did, but he started the weighing exercise driven by the view of paragraph 49 that to treat these policies, both in relation to the countryside and green gap, as being out of date. The same might be said with regard to policy NE4. That's the green gaps policy. My Lords would look at that just for a moment. That's at page 2269 in Authorities Volume 4B. And any four green gaps, the following areas defined on the proposed map are green gaps in the open countryside. We're concerned with the second one, the Williston Rope gap. Exceptions to this policy only considered the end, and then the justification. These areas need additional protection in order to maintain the definition and separation of existing communities and to indicate the support for the longer-term objective of preventing, essentially, towns from merging into one another. So there's a policy which clearly has a purpose, which is quite unrelated to housing and related to what my Lords might think is a perfectly commendable objective of not allowing one community to swallow up the surrounding communities. It is, on its face, doing a particular task which would support both a social and environmental role in terms of sustainable development. In relation to NE4, the respondents take an approach which I've earlier described as being somewhat schizophrenic or, more conventionally, lacking conviction. The Secretary of State says in his written case at paragraph 8 that looking at the history of a policy is inappropriate because it's forensic archaeology. And he borrows that expression from the TW Logistics case, to which I said, in answer to my Lord Carnwath, I would return. That principle, and perhaps we should look at it because I referred to it earlier, in Authorities Volume 2B, tab 32. It starts on page 1556. This was a,
yes. Thank you.
A more or less exciting debate about what should happen to a site at Mistley within a conservation area in Tendring District Council's area. For our purposes, my Lords, if you go in the bundle to page 1563, paragraphs 14, 15 and 16 are the relevant paragraphs. And it's paragraph 14 that gives us the phrase forensic archaeology. And the reference to that is a reference to the then Mr. Ian Dove's submissions, which related to a whole lot of investigation of where the policy had come from, what the local plan inspector had said, and matters of that kind. The judge said in paragraph 14, in my judgment, this kind of forensic archaeology is inappropriate to the interpretation of a document like a local plan, or the camp is a conservation area management plan. Lord Reed explained the nature of the development plan. He then quotes the paragraph I've referred to. 15, the public nature of these documents is of critical importance. The public is in principle entitled to rely on the public document as it stands without having to investigate its provenance and evolution. That's why the courts have set their face against. He then quotes other instances. 16, but in any event, I do not consider the inspector's comments advance the case. And, my lords, may I say, with regard to the development plan, we do not dissent from that approach. In relation to the development plan, what the court described as the forensic archaeology is inappropriate, because if it were to be adopted, then luckless local people who wanted to find out what a policy said and what it meant and how it might be applied might find themselves faced with having to do a paper chase through the history of the policy, local plan inspectors' reports, draft plans, reports of all kinds, thoroughly inappropriate for a statutory development plan exercise. Unhappily, that's, of course, exactly what the Secretary of State does in his approach in his written case at paragraph 135. Because at paragraph 135 of his written case, the Secretary of State tries to rely on the local plan inspector's report in relation to policy NE4. That, I respectfully submit, is indeed forensic archaeology of the kind that the court should discourage and has discouraged hitherto on the basis of the approach referred to by Lord Justice Lewisham in TW Logistics. It is, in any event, if I may say so, from the Secretary of State's and indeed the Richborough Estate's point of view, a bad point. Because when one looks at what the inspector actually said, and we have it in the appendix, part 2,
Yes.
At page 508.
Yes.
It starts, perhaps I should say, it starts at 505. So this is what the Secretary of State is referring to against his own stricture of not indulging in it. So any 4 green gaps. The inspector's conclusions start at page 506. But at page 507, in paragraph 14.2.2, could I ask you to read, please, particularly from the 3rd line of the paragraph.
Sorry, which paragraph?
14.2.2. Just particularly the first half of the, or 2/3 effectively the paragraph. You'll see the inspector saying there's presently a visible gap, an action necessary to prevent erosion, satisfied by the evidence. And then 14.2.3, he had some concerns about the wording of the policy and he recommended a change. At 14.2.4, the end of paragraph 14.2.4, I'm satisfied from the evidence that it's necessary to prevent the coalescence of crew Nantwich and the various settlements in the immediate vicinity. 14.25, he points out that the council is right not to look at the nibbling away of the gaps. And then at the end of that paragraph, a part my learned friends rely on as indicating that, well, if it hadn't been green gap, it would have been housing. But that, with respect, is to be understood in the context of what's over the page. And over the page, you find that what the inspector was having to deal with at 14.2.6 and 7 indeed, was objections which had been raised to the green gap from a variety of different parties, including a house builder. It's a matter with which Justice Lang dealt with, and I adopt her explanation that this is no indication that this is a policy for the supply of housing. Everything that the inspector is saying, particularly 14.2.2, is indicating it is precisely because the land has particular value as a separator from the settlements, something which would support both the social and environmental role of sustainable development, that it has been subject to policy NE4. The fact that it, as a consequence of performing that function, prevents or restricts housing being built does not, we respectfully submit, make it a policy for the supply of housing. The only other, and perhaps for completeness I ought to have dealt with it, crew policy was the RES 5 policy. You might also remember that the inspector...
So what's happened, that's the report into the local, the emerging local plan.
No, that's the local plan from a very long time ago.
No, sorry, the one we just looked at.
Yes, that's the original local plan inspector's report.
Oh, I see. This goes back. Sorry, I didn't get the
That's the
date.
2011 local plan report, yeah.
Yeah, but it's the 2003 report. The inspector's report that we're looking at here is from 2003, page 504 of the bundle.
Oh, yes, I see. Yes, I was rather thrown by the reference to 2011.
So the inspector reported in 2003. The plan was adopted in 2005 and adopted with NE4 in it as a consequence of him.
The heading, reference to local plan 2011, is just misleading.
No, it's the end date of the local plan, and conventionally, in order to confuse everybody, conventionally what local authorities do is to say, here is the local plan, and now we'll see the dates that terrify some of us, local plan 2031.
Yes.
Because of the requirement to plan 15 years ahead and so on. So 2011 is just the end date of the plan. Yep. So this is a report dealing with the NE4 policy. My submission is that you should adhere, for the reasons given by Lord Justice Lewison, to the don't do forensic archaeology with development plan documents because of the problems it would create. The problems both for practically for anyone who wanted to engage with what a plan said would find himself bound not to look at what the plan said, found himself bound then to say, well, what did the local plan inspector say? What reports were there?
I mean, you accept that given that this is a 2003 plan, inspector, or this report, the plan is produced out. If looked at as of today, it doesn't provide a 5-year supply, then the inspector is entitled to give those policies less weight or assess the weight to be given to them in the light of their housing need.
He's certainly entitled to do that as a development plan policy. And the slight problem, and it's not a problem from my point of view, but what your lordships say about what the expression policies for the supply of housing means will have repercussions much wider than simply either this slightly old or newer Suffolk plan, but for every plan. And that's why I put my submissions in the way I have at the outset, to look more broadly at the statutory framework. But as I've said, there was one other policy, and for completeness, I ought to deal with it. It was dealt with by the inspector in his decision letter, Appendix Part 1. Page 55 of the Appendix Part 1 bundle and paragraph 38. The policy, I should say, is in volume 4B at page 2314. But the inspector's characterisation of it effectively adds provision for dwellings required for persons engaged in agriculture or forestry to be categories in policy NE2 is right. That's, broadly speaking, what it does. But then he says, in itself, it's broadly consistent with the NPPF, but again, its geographical extent is subject to issues related to the settlement boundaries defined under policy NE2, and hence to the reduced weight afforded to that policy. So this is an example of a policy which is consistent with the frameworks policy, so that we don't end up with our countryside spattered with individual houses which aren't needed for agriculture or forestry or anything of that kind. The inspector says it's consistent with the framework, but because its boundary, it's the area in which it operates, the countryside is defined by NE2, and I'm treating NE2 not as a policy which is protecting the countryside for its own sake, but as a housing policy. I'm going to treat this policy as out of date by way of the deeming provision, and then give it less weight. As my Lord Carneth has remarked, nothing would, of course, prevented him going on, if he'd adopted the approach we say he should have adopted, of saying, notwithstanding the fact that it carries full weight, the housing needed in this instance is such that I've decided in any event planning permission should be granted. But the route that we suggest should have been taken was the route which would have accorded with the statutory scheme and the framework properly interpreted. My Lords, the final matter of context was the framework in the context, paragraph 49 in the context of its interplay with paragraph 14. I've largely dealt with that in going through paragraph 14 already. I've invited you to note what footnote 9 does and the contraindications, and the way in which that list in footnote 9 fits with what the Court of Appeal says in paragraph 33 are policies for the supply.
Can I just go back to paragraph 49?
Yes.
Itself. Is the word relevant in the second sentence helpful? Is it really a transferred word? Is it policies relevant for the supply of housing? What's the word relevant mean on your case?
Relevant policies, we are all agreed, my Lord, are the policies which are relevant when considering the site, and this is a paragraph about housing applications, see the opening two words.
Yes,
so relevant policies are relevant policies in considering the site, the subject of the housing application.
Yes, I see. Thank you.
And well, I've dealt with the rest. I won't say anything further. Paragraph 49 and the interplay with paragraph 14, it's important to see that the consequences of the deeming provision of paragraph 49 are played out, in fact, in paragraph 14 in the way that we've seen going through the paragraph. So, my Lords will have noted the words in paragraph 14 that I referred to in the second bullet point under decision taking, where development plan is absent, silent, or relevant policies are out of date. There's the hook back to paragraph 49, granting planning permission unless. And as I've said, it's important then to see how footnote 9 plays out there in the context of the national policy, and to look at that list in the context of what the Court of Appeal was saying were relevant policies for the supply of housing.
What? Yes, I see.
In my respectful submission, the Court of Appeal's approach produces something which is effectively rather circular, because on the one hand it says these are all policies for supply of housing should be regarded as out of date. Then it gets us to paragraph 14, which tells us actually these are indications that planning permission should not be granted. The problem with the Court of Appeal's approach is that on the way, it has managed to put the carefully prepared and considered policies of the development plan into the category of being deemed out of date. My Lords, that ought not to be so.
I see your point exactly, but it rather seems that taking either of the routes, the one that you prefer or the one that Lord Justice Lindblom preferred, you could in fact reach the same result. That would be the sacrifice of greenbelt land or some other conservation area land in the interests of housing development, if the local authority can't come up with the sites.
That is true, my Lord, and it's no part of my case to say that somehow, and I'm not advancing a case which is, if you'll forgive the analogy, a get-out-of-jail-free card for local authorities who are not providing housing sites. The route is available, a route which, my Lord, I'm sure, would be a conventional route simply of weighing. And what should happen, one of the Court of Appeal's concerns was, well, how is the government going to achieve the objective of significantly boosting the supply of housing if we don't take this interpretation? And the answer is, I respectfully submit, very straightforwardly, very easily. Because what happens if you take our view is all of the policies in the plan which do properly relate to housing and which are to do with the housing numbers, any restriction on the numbers, any restriction on types of sites suitable for housing, all of the matters we've set out at paragraph 85 of our written case. All of those matters are put to one side. And there is, from that point of view, therefore, a clear canvas to consider the housing issue and the weight to be afforded to the housing considerations. And
do you say the words for the supply of housing on the Court of Appeal's case, as it were, on the Court of Appeal's view, add nothing? If it just said relevant policies should not be considered up to date, would that have the same effect as the Court of Appeal?
Practically, it would, because although my own friends will be able to find some examples that aren't tangentially aren't relevant, but practically speaking, rather as Justice Lang said at paragraph 51 of her judgment, these words, relevant policies for the supply of housing, if they mean what they say, are not to be taken as reading relevant policies which restrict the supply of housing. And I remind my lords, if you'll forgive me, there are at least 3 or 4 references where the minister has told us this language is intended to be simple and straightforward and easily understood.
Well, no, we've had all that, but I'm just asking you a narrower point, whether the words for the supply of housing actually add anything on the Court of Appeal's.
No, not practically, they don't. Not practically. Not to say there won't be policies that you could identify that would be out with them, but in practical terms, they don't. And that's why I made the submission earlier on that the words for the supply of housing are words of limitation in relation to relevant policies. Words of limitation which need to be given effect to, and if they're not given effect to, winding back in the case, then one ends up with a statutory framework which has put everyone through the cost and expense of the hoops we've identified to practically no very good effect.
I take it that the local authorities favour the narrow interpretation because it would give them greater development control opportunities than the wider interpretation would do.
No, that, with respect, that's not quite right. The local authorities favour the narrower approach. One, because it properly respects the investment that everyone will have made in the production of plans and policies that relate to a wide range of considerations, of which for some people locally will be immensely important. Ecological, environmental considerations, landscape considerations. They will have produced evidence to an inspector, for example, to demonstrate that some area has particular characteristics. Respecting that doesn't, as I've said, enable the local authority to escape its obligations, but does mean that that whole process which has gone to the production of the policy is not effectively put to one side on the side wind of the construction of for the supply of housing. So, my lords, it isn't with a view to saying we want to get rid of development. It's with a view to properly respecting the process and arriving at the conclusion by the right route, which will make a difference to the credibility of local plans. If my lord, you to imagine that in these circumstances, everyone who contributed to the process was to be told, well, I'm sorry, I know the policy says it's about a particularly special piece of landscape, but actually you ought to realise that's a policy for the supply of housing. Most ordinary people, my lords, would be aghast at such a suggestion. They would say, rightly, why did we bother to produce all this evidence if at the end of the day it can all be trumped by effectively a housing calculation? My lord, to put it in a way which can conveniently be summarised from the different context of Adedoyin and borrowing if I may respectfully, from the language used by Lord Justice Ricks at paragraph 82. If what the Court of Appeals says is correct, then it's something that should be done clearly and not buried in ambiguous wording. And that's paragraph 82 of Adedoya. And that, I respectfully submit, is the right approach. If this is what the Secretary of State says his policy is, then he should own up both to Parliament and everyone else and say, I know I told Parliament that the local plan would rule the day, sustainability considerations would rule the day, the countryside would be protected. But what I actually meant was it would be protected unless there was a housing need, in which case all these considerations would be trumped. And he ought not to be allowed to do that without an explicit amendment to the policy, which is, if he wants to do it, is of course within his remit.
I hope this isn't an unfair way of putting it, but it rather looks as though since paragraph 49 deals with ad hoc applications rather than with the drafting of plans, then if a local authority were to respond to a housing application, let's say in Greenbelt land, and if the planning officials came in with all guns blazing on Greenbelt and the sacrosanct nature of it, then if that were to succeed, effectively the planning authority would, in a sense, escape its obligation to find the sites.
Well, not if the decision maker took a purely conventional approach of saying, here there is such a difficulty with housing provision that I'm going to give it such weight. And it has happened. There has been housing development permitted in the Greenbelt by the simple process of a decision maker saying, the housing need is sufficiently serious, I will give it such weight as it deserves in this particular circumstance. And by that means, the housing need is met, but it's met in a way which respects the approach which we've referred to. My Lords, I've exhausted my time. Now I make clear, in terms of the timetable, our submission with regard to issue 2, is it a question of law? I'll set out in the written case, and I'll respond to my learned friends with regard to any submissions in that regard when I come to reply in due course, unless I can help your lordships further.
Thank you very much indeed. Mr. Richards. Good. Thank you very much indeed. Right, we'll adjourn now and resume again at 2 o'clock. Court's now adjourned. Thank you.